And today's subject is going to be on advanced estate planning. And when we talk about estate planning, generally we're talking about wealth transfer planning, beneficiary protection, incapacity planning, and we're trying to get assets to the next generation, protect people, and plan for your incapacity. When we deal with advanced estate planning, we're going beyond the most basic goals, and we're thinking about unique assets, unique family situations, and also unique levels of wealth. So that's what we're going to go into today. But it is a seminar, so it's a survey of some of the tools that we have in our toolbox, the issues that we see, and then some specific examples of how we've helped people. And so in those specific examples, we're going to be able to see the application and how we've really drilled down and solved people's issues. So just a little bit about me. My name is John Martin, and I'm a certified estate planning specialist, and my office is in downtown Palo Alto. I've been practicing law for 16 years. I started out in Menlo Park, working with other attorneys, have had my own practice for most of that time, and now we have a 5-person law practice in downtown Palo Alto. And we establish estate plans for families, for individuals, for businesses. We work with a really broad spectrum of different people who are working in companies, people who own their own business, families, people with special needs children, people who have charitable intent, single people, so just a big range. And I've got all the education and details here too, which is important, although I don't feel especially motivated to go over that each time, but it's written there for your reference. So we're talking about at the very beginning that we're trying to achieve wealth transfer, beneficiary protection, and incapacity planning goals, which that's what estate planning is, right? But we're doing it at a higher level. We're doing it based upon unique assets, a unique wealth situation, or a unique family situation. And so what do we mean by a unique asset? What do we mean by unique levels of wealth? What do we mean by unique family situations? Well, there could be assets like a family business, assets like intellectual property, maybe life insurance policies that are very high value, maybe assets that are subject to claims because they're connected with a business where there could be people who might sue, like employees or a union. Maybe retirement plans that are really large, but they're taxable, and so we're thinking, how can we minimize the tax from those retirement plans? We're also thinking about unique levels of wealth. So you might just say a large number, but sometimes it's more complicated than just a large number because there can be valuation issues. If you look at a stock and you've got a price of the stock, or you're looking at a bank account and there's a value of your bank account, well, that's easy. But what about things that we don't really know the value of because we have to get experts involved to tell us what this might be on the open market if we were to sell something? And there's also ways that value can be discounted because a lot of times it's a matter of opinion what something is worth. So we'll see how that's really important when we're looking at advanced estate planning. We're also looking at unique family situations. Because unique family situations come up all the time in my practice too. So of course, a very common one is, hey, I have this beneficiary, this child, and they're going to need some more time. And that's a very basic one. But more fundamentally, we might have somebody who's addicted to substances, or they're in a very troubled marriage. And we also have a lot of people who are in blended families. It's very common to have children from a prior marriage, to get remarried, to have assets that are shared with your spouse, and then assets that are kept separate. And how do you make sure that your children from your prior marriage will still receive what you want them to get? So that's a blended family situation. So we've got a lot of different unique family situations. And I didn't mention also special needs children, special needs beneficiaries, also a unique situation because they might have benefits that they would lose if they just received an inheritance outright. So I wanted to start with the unique assets. So we're going to go through different kinds of unique assets. I'm going to talk about specific planning issues and tools. So issues and tools that we use with unique assets. Let's start with a family business. So now family businesses are distinct from very large corporate interests, right? We're thinking, and we're also distinct from partnership interests that you might hold in like a large real estate investment trust or a large real estate investment partnership. A family business is going to be more of the typical businesses that you encounter as a consumer out there in the community. You're going to a restaurant, you're going to a doctor who has a practice, you're going to a store, you're going to a jeweler. So these are clients of mine, these people who own these businesses, right? We have clients that own jewelry stores, that own restaurants, that run these businesses. When they come to me, they say, John, what am I going to do if I become incapacitated? What am I going to do with my workers, with my payroll? What am I going to do with transitioning my business if I die? How does my spouse get the value of this business if I died suddenly? How does this get transitioned under my estate plan? If I have a child that wants to take over my business, how am I going to make that work but not cheat the other child? We might not think about all these issues every day, and in fact, a lot of business owners don't think about these issues either because they're busy running their business, right? They did really well starting their business, running their business, so they don't like to think about this because it's not something that adds to their bottom line right away, right? Successful business people are often thinking about that, and they don't think about these long-term issues. And a lot of people joke, don't ask your attorney for business advice, right? Because we actually slow things down and make things more expensive. That's not always true. I mean, but it does have some truth to it because we think about liability, right? We think about the possibility of lawsuits. We think about what might happen if the unthinkable happens, right? Of course, mortality, I've heard there's actually a 100% rate of mortality. Don't get too afraid. I didn't change that. That's just the truth. So it's just preparing for something that will happen. So what's in our toolbox for this kind of issue? Well, one thing will be a contract called a buy-sell agreement where we will identify a potential purchaser of the business. So this might work with an employee that's in the business. It might work for somebody who's coming in and getting some shares of the company, and then you could end up having a cross purchase where you're getting some life insurance. The life insurance gets paid at the time of your death, and then that other owner goes in and buys your shares at the time of your death, cashing out your spouse or your family. And I'll just share an example of how this actually worked in practice. We had a physician's practice, so a doctor who had brought in some employees, some other physicians that were working with him, and he says, I want to transition my practice. And so we entered into a buy-sell agreement where over time he had identified these other doctors. They're growing in the practice, they're getting seniority, and at a certain time he did get them an equity interest in his practice where they own a percentage. And then he entered into a contract with them, funded with life insurance, where he said, okay, if I die suddenly, you're actually going to buy into my practice, but that would be way too expensive for you to do with your own cash. You just don't have the money, so this life insurance is actually going to be there. It's going to go to you. You're paying the premiums on it, right, out of your salary, and then my spouse gets the money for my shares at the time when I pass away. It works, and what's great with that too is that we get something called a step-up in basis. You know about cost basis? These shares that are owned by that client when he passes away are actually going to be adjusted in basis so that when those get sold at his death, there's zero tax. Zero tax. So we're able to take advantage of the tax code when we're planning for that. So that combines the key man life insurance, so life insurance on this key owner of the business, with the tax advantages that go with it. We're also thinking about creating a living will for that business. So you think about living wills for people. What about a living will for a business? So a power of attorney that's going to designate somebody for that physician to go in and to manage the accounts, to manage the office itself, to manage all the bill pay, in the event that there's a sudden incapacity. And so we can designate somebody. In fact, myself as an attorney, it's actually right there in the rules of professional conduct. I'm required by law to do that. And so, of course, I've done that. Now let's continue. That when you have a family business and you're gifting, remember I mentioned the inequality among children? Inequality among children. So a lot of people say, let's start gifting this to my family. I want to get it down to my son, my daughter. I want them to take over the business. I want them to own something. I don't want to give them too much. They'll get spoiled. They'll think that it's all going to come to them. They probably are spoiled anyway, but that's a different issue. But the valuation can be a key part of our plan. So the valuation is going to be the value that we report on that gift tax return or on your estate tax return when you pass away. And did you know that valuation is not an exact science? So I might have a restaurant, right? I have a client that owns a wonderful restaurant that I eat at all the time. And that restaurant, there's going to be some value to it if it's sold on the open market, right? We really don't know what that is. We know what other restaurants have sold for, right? Those are comparables. It's not like in real estate, where you might go down one street and all the houses kind of look similar, right? Especially like if it's a suburb and each of the lots are the same size. Business is completely different because you've got their own market, their own clientele. So we can actually go to somebody and get an opinion of value and go to somebody else and the values might be widely different, right? And we can also ask that valuator to give us a discount. And actually, when we're fractionalizing a business and giving some percentage to a child, sometimes we can get a valuation discount of like 20 or 30%. Now, this might just sound like numbers. So how does that fit in to your planning? Well, imagine that you have $1 million asset and it's all taxable. Does anybody know what the estate tax rate is right now for taxable estates? Anybody want to throw out, what our estate tax is? Our rate? Okay, so it's actually 40%. 40% at people's death is going to be taxed on the amount that is above the exemption amount. The exemption amount changes around with politics. 40% is a big number. So imagine you had $1 million asset, right? And it's 40% tax. That's $400,000 that you're paying, right? Now imagine if we can take a haircut of 20% of that business's value. So instead of worth $1 million, now it's worth $800,000. So now you just saved hundreds of thousands of dollars in taxes by getting that haircut. So that's why discounts are important. So if we can get a valuator to tell us that this business interest is worth 20% less, we've saved our client hundreds of thousands or sometimes millions of dollars, right? And so that's a huge tool we have. Step up in basis, I talked about a little bit earlier. That can occur for a business too, and we mentioned that with the buy-sell agreement. 6166 election. So now we're talking about when do we give and when do we hold on to assets, right? So giving can have some great advantages because you can lock in the current exemption. Does anybody know that right now we have a tax law that's going to expire in a year? So at the end of 2025, our current tax law will expire. We have the most generous exemption amount that any of us have ever seen. I'm looking around. There's never been a more generous exemption amount than the one today, right? It's $13.6 million per person. So you can, as a married couple, pass $27 million at your death with no tax, right? But some people are saying it's going to expire, it's going to be cut in half. So it's going to go down to 13.6 million as a married couple, right? Which is half, and then just over 6 million as an individual. So some people right now that are in that 13.6 million as an individual, or 27 million as a married couple, are saying, we're going to have to pay tax if we survive past 25, and that's true, right? If they die and the law hasn't changed, before they die. So they could use up their exemption now with gifts, right? And then they've locked in the current exemption. So that might be a good strategy for some people. But then they've lost an important election for their family business. The 6166 election is the ability to pay tax in installments. There's no other benefits for family business owners on the estate tax return 706, except for this one, which is that you can, if you own a business at your death, Your children, if they take it over, they keep the business, they can actually pay the estate tax. It's actually over 12 years. And it's a pretty favorable interest rate. If you are inheriting money and you need to pay a bunch of tax and you go to the banks to get a loan, they're not going to give you the rate that the IRS gives you, and you may not be able to get credit. But the IRS will give you credit if you own your own family business. There are also unique allocation issues that come up at the time when a spouse will pass away that enter into our advice that we give business owners. Because did you know that a lot of people, when they pass away, they have multiple trusts that get set up, right? Q-tip trust, family trust, right? And did you know that that spouse is often, the surviving spouse trustee, they can decide where these assets get put as between these two trusts. Now, that can lead to a lot of issues down the line when it comes to where the future value is, where it comes to asset protection, where it comes to tax planning, and so we want to be looking at that as well. Now, something that may be a little bit more fun than the family business. What about the family cabin? So the place where people like to go and meet and really enjoy. So I had a client like this. He had a family cabin out on an island in Maine. So we'd love to go there. You know, his family came out. They live, you know, locally here, but we'd love to bring the family out and go on vacations there. So, John, I want to make sure that this cabin is always going to be used by my family. How can you make that happen? I said, well, we have a lot of different tools in our toolbox. We can create a trust. You know, we can go in and say, house will be held in the trust. And the issue with that, of course, you have to have some money in the trust to pay for all these things, right? Because if you say your kids are going to pay for it and they don't, you know, what are you going to do? Are they going to break the trust? You're going to terminate it? It gets distributed? You're going to kick them out? So you say, okay, we'll put some money in the trust and we'll have some provisions saying that the house will be held in this trust and the kids can go there and enjoy it. But there's some other ways we could have done that too. We could have created a business entity and we could have provided that there would be dues that would be paid, like assessments by the different members, and put in the kids as members. That could have been a nice plan that we had. We could have put money in the entity as well. So there's some different tools that we could have used. But we want to make sure that there's some sort of viable exit for this so that the kids don't feel like they're trapped. Unique property can also be intellectual property. So I had a client who was a very well-known, whose father passed away. He was a very well-known philosopher. So he had this huge body of work. You know, it was at a big university in the area that I won't name. And there's lots of speeches that are being given. There's websites. There's like conferences. People are always talking about this philosopher. It's pretty cool to be involved with that estate. So what are we going to do now with this legacy? So we, representing the surviving spouse, she's putting together her estate plan, and we have a literary trust that we are able to create where we're able to hold on to this in perpetuity, the royalties, the copyrights, but also have some of the family members who have a vested interest in their father's work to make sure that there's going to be some people who really care about it, who make sure that there's not just some crazy, you know, stuff written about their father, right? That they're able to be responsible about who's putting on these presentations, who's hosting these different gatherings. I had a client that was a TV star like back in the 1950s. It was really cool. I had never heard of him, but then I went back and I was watching all these shows like, wow, this guy's really good. And he passed away just a little bit ago. But we were able to make sure that his surviving spouse's trust dealt with the royalties that he was getting still from these different shows that he did back in the 1950s and 60s. But that required some specific language in the trust to make sure that those assets could be identified. So I want to mention life insurance is a special asset as well. So, you know, a lot of people hear about life insurance because there's life insurance agents out there and, you know, they sell them and so they go over all the reasons why you should get them. There is a lot of different reasons why people get life insurance. Sometimes it's to create liquidity. Sometimes it's to help somebody who maybe you're offsetting the value of something that's going to someone else, and so you want to create life insurance to do that. In fact, that could be a great way to offset the value of a business that you're giving to a child, is offset the value with life insurance that you're giving to the other child. Special needs children, there's a lot of assets that we wouldn't want to give to special needs children, like retirement plans, because often those assets will flow through to them, the minimum distributions, and disqualify them from benefits because it gets paid over time. There's a lot of taxes that get thrown off of retirement plans too. So when we pay them into a trust, trusts pay higher tax rates than individuals. So we often don't want to have the trust receiving all these monies when we want to just benefit that special needs child. So we'll set up a trust that can hold the life insurance. When we have a taxable estate, we want to get that life insurance out of the estate, and we can do that with what's called an irrevocable life insurance trust. We also have some clients with vineyards, clients with farms. Those are unique as well. And one thing is with valuation, we can sometimes put in a conservation easement. Conservation easement would be where this is always going to be open space, it's always going to be agricultural. We can actually lower the value on paper so that then when we go to file the gift tax return, go to file the estate tax return, we're reporting a lower value. We talked about retirement plans. I just wanted to mention this has really changed over time. Maybe you remember the good old days when retirement plans could pay out to children and they could stretch them out over their life. Maybe you have a plan like that you inherited from your family. That is not the law anymore. There's now what's called the 10-year rule, where you die, your kids have to withdraw, pretty much all kids, unless they're in their minority still, have to withdraw over 10 years. And then we just got recent regulations that were issued that said that those distributions from retirement plans have to start coming right away. It can't wait for 10 years. It has to be life expectancy distributions immediately, and then you have to take everything out by 10 years. This is a huge tax hit that's resulting now for kids, really a sad thing. I think that's happened because now we don't have the tax benefit that was enjoyed in the past at all. But there's also another thing too, which is that not too long ago we had a Supreme Court decision that said that retirement plans that pass on to kids don't have any bankruptcy protection or creditor protection or lawsuit protection. So you may have a 401k or an IRA. Did you know that if you go through bankruptcy, your 401k is not is not subject to bankruptcy? It's exempt. Did you know that you have lawsuit and judgment protection with your 401k? And with IRAs, you also have protection, but it's just up to $1 million, right? 401k is unlimited protection. IRA is just $1 million. But inherited IRAs, inherited 401ks, no protection. So sometimes when we're thinking, hey, how can we deal with that and keep the protection, we will create a trust, and we'll say it's worth it to pay the higher taxes if we have a high-risk beneficiary, if we have a high-risk situation, or if we have a blended family and we really want to make sure that these retirement plans are protected for the children of the person who's passed away. So we'll create a trust and preserve those retirement plans. Okay, so now we talked about unique assets. What about unique levels of wealth? Unique levels of wealth, high numbers, and then also maybe we don't know the numbers, but we know that it's complicated, like complicated businesses, complicated in terms of how the valuation might be figured. So we want to think, and when I was first starting my practice, I had a lot of mentors. One of my mentors who I really admired told me, John, if you want to know estate taxes as an estate attorney, prepare estate tax returns. Well, why would I want to prepare estate? Don't CPAs do that? Yes, CPAs do that. Prepare estate tax returns, because if you know estate tax returns backwards and forwards, you will be able to know all the deductions, all the credits, all the ways in which this gets reported to the IRS. So I started doing estate tax returns, and guess what? Do you know what the audit rate is for taxable estates with estate tax returns? The audit rate, any guesses? The audit rate, 100%. That's right. There is a 100% audit rate. So every estate tax return that I filed, I've gotten, not a hard audit, but I've got a letter. It's a letter audit, right? So I get a letter back from the IRS, and they ask for things. Give us, these questions. It is 5 questions, like, where did the guy who passed away work? And what was his phone number? For taking calls regarding, the contracts that he had with tenants. What's going on here? Because there's these deductions that you can claim, there's credits you can claim, and it has to do with your specific life situation, right, that you have. So you better know, gosh, I know these issues now backwards and forwards, so when we're preparing the trust, when we're advising our client on how they should live their life, then we're informed by the way the estate tax return is being prepared. I will give you an example. I am working right now with a gentleman who runs a property management business, okay? Do you know rental properties could look like passive wealth to the IRS, could just look like passive investments, or it could be an active operating business that you're managing. An active operating business that you're managing, remember you get that election to pay your estate tax in installments, right? Where is your office? Do you have a phone number where you can have tenants call you? Do you have more than just a label? Like, do you have people who answer to you, right? Do you negotiate the tenant contracts, right? Do you edit them? So I can actually counsel people and say, hey, we should change your job description on the website, right? We should do this, we should do that, and it should be real. Like it's not a fraud approach. Like we really want you to do these things. But now when we're preparing the estate tax return, when you die, I can be confident that you're going to get this election. Valuation discounts. Valuation discounts can be very aggressive. They have been way more aggressive in the past. We were talking about how you can lower the value on paper for assets and get huge amounts of tax savings, and it can actually multiply. So you can create gifts and you get a discount on the gift, and then what you keep also gets a discount at your death. Or you sell an asset to a trust for your child and you take back a note, right? And the note then lowers in value over time, but then you can discount the note at your death because there's a possibility you might not repay the note. So it's like you're stacking all these discounts one on the other and using the tax code for your advantage. I did want to talk about portability elections. This has been around now since 2012. Maybe you heard about this. It was they're always coming up with a tax law where they say, we're going to put the attorneys out of business. We're going to make it so easy. It's going to be really simple. And so this is one of the things they did back in 2012. They created an election called the portability election, which is where you could reserve your deceased spouse's unused exemption, and it would be automatic, right? This says automatic. You can reserve. So if your spouse dies now, you can do this. You can reserve their unused. Does anybody remember what the exemption amount was? I said it earlier today. I can pick on the back row if you want, but no. It's $13.6 million, right? And it's expiring in 25, right? And it's going to go down to half of that amount. So the portability election allows you to file an estate tax return, and then you don't have to check a box. You just have to make sure you don't check the box. And if you don't check the box, then you get the election. So you're automatically reserving the $13.6 million so that when you die, you have at least your spouse's $13.6 million. Who knows what you'll have at the time of your death, but you'll have your spouse's. There are some problems with that. I just had this happen to a client whose husband died, okay? She reserved the $13.6 million, and you know what happened? She found another guy, right? And she's remarrying. Now, she found another guy. He's older than her, okay? You can only have the last portability election of your last predeceased spouse. Like, oh my gosh, what if her new husband dies before her? She's not going to have the $13.6 million. Okay. Her new husband is worth over $100 million, right? He's already used up all of his exemption amount for his kids. He has no exemption amount to give her. It's like, oh my gosh, we need to talk about this before you get married. You're not going to have your portability exemption to give to your kids. I'm just panicking, Says, no problem. My husband's going to give me $20 million. Oh, okay, all right. It'll be fine. It'll be fine. Because even if you pay taxes on that, you're still ahead. So this is the conversations I have with people. Okay, so then what about some other trusts? So we have a lot of different ways we can avoid tax with special kinds of trusts. So one of them I think is really cool, really cool. Bear with me here because I'm geeked out about kind of weird stuff, right? But charitable remainder trusts, charitable lead trusts are a way to give to charity, but you create a benefit for yourself or your family. And what's great is you can kind of have your cake and eat it too. So let me give a cool example of a charitable remainder trust. Lots of single people do this, right, who have no kids. Very common. I have a client, they're thinking of going to the, they're not sure, is it the Sequoias, the V, Channing House, right, one of these senior living places that are pretty cool. I'd love to be able to afford to go to one of those places. But the problem is she bought her home way back when in Palo Alto, right? So the cost basis is really low. The value is really high. She's going to pay all these taxes, and then she's got to pay the $1.5 million entry fee at one of these places. I'm like, oh my gosh, that's so expensive. Can't you just get caregivers at home? Like, no, I want to go into one of these communities. And then the rent is like $6,000 a month for one of these places, right? And then it goes up when you need more medical care. So anyway, she's like, can you come up with a plan for me? Okay. Let's put half of your home into a charitable remainder trust. Okay. Half of your home, when we sell it, there will be zero capital gains tax because charitable remainder trusts don't pay any capital gains tax. That charitable remainder trust will pay you an annuity for the remainder of your life, 6% per year. That's what you would get from your investments anyway, but you've got a bigger pool of money because you're not paying taxes on the proceeds of the sale of the home. You have the other half of your home that you're holding individually. We'll sell that, but we have your $250,000 exclusion, plus you just made a charitable gift to the charitable remainder trust. That's deductible on your income tax return, so we can offset your capital gains tax for the sale of the house. John, I can go to Channing House. So it was a wonderful conversation. And then what about charitable lead trust? This is pretty cool too, because we can actually do the reverse of a charitable remainder trust. So you know how a charitable remainder trust, you're creating a benefit for yourself. What about creating a benefit for charity and having the remainder go to your family? Can you do that? Why would you do that? Okay, I have clients that say, John, I have to pay estate tax at my death. I don't want to gift a bunch of money right now. I just want to hold on to all of it. But I don't want to pay any tax at my death. Can I zero out my taxes? Yes, you can do that. We could put a formula in your trust that says create give the non-taxable portion to your family, right? Today, for a married couple, that's $27 million. Give that all to your family. Put the rest into a charitable lead trust that pays to charity for so many years as are necessary to zero out the tax, and at the end of that term, it reverts to your family. We could do that. We could create an estate plan that pays zero to the IRS, right? Zero to Uncle Sam. It just creates a charitable lead trust. You've got your family foundation that's receiving payments from that charitable lead trust over, maybe we have intervals of 10 years, 15 years, and 20 years. And then each of those charitable lead trusts terminate in succession so that your family members will get the balance of each charitable lead trust at 10 years, 15 years, and 20 years. So you basically paid off Uncle Sam with charitable gifts over that 20-year period. And then your family ends up getting all the wealth. Do they end up with more? Not at day one, but because of the way the charitable lead trust is set up, the principle of that trust is growing over time. So if we can beat the annuity, so the annuity is like 5% that's going to charity, but if we can make 8% on that money, does anybody know what the S&P 500 has averaged over the last 20 years, something like that? like 10%? I actually don't know the answer to that question, but I was going to see if maybe somebody knows. But I'm pretty sure if you just did that, like bought an index, you probably would beat the annuity that you have to pay to charity, and with compound interest over 20 years. So I run these calculations for people, and they're like, whoa, this will be like $20 million, $30 million at the end of this term. My kids are going to get more overall than they would have if they paid the tax to Uncle Sam. Yes, and so people love that idea. Really briefly, because I don't know how much time we have other ways we can get wealth to family. One of them is my favorite kind of trust. It's called an intentionally defective grantor trust. It's my favorite kind of trust because it's just like this wonderful loophole that just works in this wonderful way. So Congress actually wrote different parts of the tax code at different times. So one part of the tax code they wrote in the 1930s when people were really trying to avoid income tax with trusts, right? So they said if you retain these powers over the trust, it will be included in your estate for income tax purposes. In other words, you have to pay income taxes on everything in this trust. Because everybody back in the 30s, they were all trying to avoid income tax. Then later, President Reagan, right, going to lower taxes. He lowers all his taxes. Unfortunately, we weren't able to pay our bills when he did that. So he said, okay, let's raise taxes, but not tell people we're raising taxes. Okay, so they created this other part of the code, which looked just the same as this provision that was written in the 30s, except it was about estate tax. So that, okay, these trusts will be included in your estate if you have this power, this power, this power, this power, this power. So you look at these lists of powers, and they line up almost identically, except for 3 different areas. So you could retain the power over the trust to swap assets in and out. You can retain power to borrow without adequate security, or you can retain a power to add and remove charitable beneficiaries. I don't know why they have those 3 powers, but that's how they wrote it in the 80s. They didn't write it that way in the 30s. So we can actually intentionally trigger those powers and make the trust includable in your estate for income tax purposes, but excludable for estate tax purposes. Why would we do something crazy like that, right? Because think about this. If you sell something to yourself, do you have to pay capital gains taxes on it? Like if I create a contract and I say, I sell my house to myself, like do you think the IRS will say you owe capital gains taxes? No, of course not. That's ridiculous. If you rent something from yourself, do you have to pay income taxes on the rent you pay to yourself? No, that's ridiculous. Why would anybody have to pay income taxes? If you loan something to yourself, would you have to pay income taxes on the interest? No, you don't have to pay income taxes on the interest that you're charging yourself. Okay, so if I create an intentionally defective grantor trust and I sell my home to the intentionally defective grantor trust, and everything in that trust is out of my estate for estate tax purposes, do I have to pay capital gains tax on the sale of the asset to the intentionally defective grantor trust? No, because for tax purposes, it's treated as a sale to yourself. In fact, you can even use your Social Security number as the tax ID number on it. Can I loan money to the intentionally defective grantor trust, take back a note, and exempt the interest from income tax? Yes, you can do that. So you can create these tax-free sales to the trust, but everything in the trust is out of your estate for estate tax purposes. I think that's just wonderful, but you know what? The Congress has been talking about eliminating that, but they're talking about it for a long time. They've been talking about it for decades, and they haven't eliminated it. You know what it probably is? Probably that they're all using that trust too. So wait until I get my estate planning done, and then we'll talk about it. QPERTs, have been around for ages. This is actually an IRS creation. So they actually wrote this trust into the code, and actually they do that for charitable remainder trust, charitable lead trust too. We just use the IRS trust itself. And it's a trust whereby you can give your home to your children. These are kind of rare. I've probably done 5 of them, so really not very many. But it's actually kind of nice because you can say, I give my home to my children, but not now. I give it in 5 years, 10 years, 15 years, 20 years. And do you know the IRS will let you do an actuarial calculation and discount the value of your home? So I did this with a home in Woodside. It was like a $5 million home. but then we only reported like $750,000 gift because it was so much in the future that the kids were going to get the home. So that's kind of cool planning. And it's actually very easy to do, and it's automatically approved because it's an IRS creation. We talked about valuation discounts. Okay, so now unique family situations. Unique family situations. So special needs trusts, these are less popular than they used to be. I used to work with this other attorney. He's a wonderful guy. He did Medi-Cal planning. I never really liked Medi-Cal planning because it kind of felt a little bit wrong, you know, where you get people who are millionaires, then they can apply for public benefits by putting all their money in a trust. And I was this doesn't feel right. So I just never really specialized in it. Anyway, that's kind of gone out of practice, out of vogue, because health insurance now, after healthcare reform, it's not based on assets anymore. So putting, you know, millionaires putting their assets in trust to go on public benefits, it's not really happening like it used to in the past. However, it's still the case that an asset test, if you need long-term care, so if you need to go into a nursing home, or if you need to have in-home caregivers care for you, or if you are on SSI, that's supplemental Social Security income, or if you are, I think there's one other thing that you need. I forget what it is. But the special needs trust still is important for those kids who are going to be on welfare or they're going to need long-term residential care. Blended families. So we use Q-tips a lot. Do you know what a Q-tip is? It's the thing you clean your ear out with. No. Well, yes. But no, it's also a trust that we create for blended families. I do this all the time for blended families because we have a lot of blended families as clients. So that's where you have kids from a prior marriage. Maybe you have shared kids too. And what happens is you can't predict the order of deaths. Now, my wife and I have agreed we're both going to die at the same time. So we're not going to have this issue. But what if you can't predict the order of deaths? What do you do? Well, if you want to ensure that your kids get something, you could leave your assets to your spouse in trust, right? And your spouse could be even trustee of that trust. They can control buying and selling the assets in the trust, but they can't withdraw the principal. So whatever's left in that trust can go to your children of your prior marriage. So that way you don't leave your spouse destitute, right? They can live in the home that's split between the Q-tip and the trust that's theirs. They could, you know, live off of the rents for a rental property you put in there, right? If you want some extra insurance, you can add somebody to serve with your spouse. Like you really don't trust them that much, so let's make sure that they're... No, you trust them completely. It's just trust but verify. Okay, so then let's go ahead and proceed with addicted, troubled beneficiaries. I had this for a client recently. We had, their daughter, kind of, very bright girl, right? Went off to a great college, and then just something happened, right? And she started using substances. She dropped out of school. She's really smart. And then the parents are like, what do I do, John? It's been a couple years. We kept thinking she's going to rebound. But she's just sitting in her room, we got her into a recovery program. She's in and out. What do we do? I'm like, you know what? Whenever you're planning for your children, you don't want to think, hey, it's going to be like this in 5 years. We're going to be fixed. We're going to be good. It's going to be like this in 10 years. We're going to be fixed. It's going to be good. You have to think, what is it right now, right? If right now you would not want to leave that inheritance to her outright, don't do it. Don't do it. You need to put in some provisions that say there's going to be some testing, there's going to be some third-party trustee, and it's not just going to distribute that to her at a certain age, right? Maybe the trustee is going to make some determination based upon testing, based upon where she is in life, that, okay, you can step in now and you can have some more access to your assets. And then you come back to me as a parent. We'll come back in 2 years, 3 years, reevaluate. She went through some great programs, she's feeling better, she's responsible, she's working, and we can edit that trust for you. That's what's great about a revocable living trust. You can come back and change it up until the point where you pass away. All right. Oh, and I used to get a lot, I don't get this anymore, but some people will say, couldn't I just buy an annuity, like have my trust pay for an annuity? Don't do it anymore. They changed the qualification rules for annuities. Now, if it's the only asset you have, right? So if the trustee's buying an annuity for like a child and it's a replacement for a trust, if that's the only asset you have, they won't write the policy anymore. They won't write the annuity. I ran into that issue a couple years ago, and I was shocked. So I said, well, the trust is drafted this way. It says buy an annuity for this child. And it was, I think, a poor man's trust. They didn't want to have a trust. They just said, let's buy a financial product that pays installments to the child. It doesn't really work anymore because they have all these qualification guidelines that make sure it's not your only asset. Okay. We talked about some of the family business, and equalizing. Let me tell you one thing that I did recently with equalizing specifically is that we had a business that was being left to the sons, and then the daughter was being left out. So we put in an equalization provision. So equalization provisions can be kind of tough because you don't really know the value of something at the time of death. So I have to give a big caveat. I said, you know what, you're going to need to audit this over time and come back, and you should value your business. You should update the valuation. You should look at it frequently. But I want to move on from that and talk about gifting. So we do some litigation in my firm. There was one year where we were litigating an issue where we took opposite sides. So for one client, we were on one side of the issue, and then for the other client, we're on the other side of the issue. Different lawsuits, right? But it was dealing with this issue, which was, what if the trust says, I made a loan or gift to my child, they have to pay it back at the time of my death, right? And then what if a really long period of time passes, like 20 years, 30 years, right? So there's no records going back all that time. And what if they said, like, back in the 80s, because interest rates were like 12% in the 80s, this loan goes to them, it's $200,000, and it will, accrue interest at 12% until paid, right? And then 40 years passes, right? Is that fair? That there's now millions of dollars owed by this person back to the trust. They get nothing under their inheritance. So I argued that's not fair because I was representing that person. But then on the other side, I was representing a trustee, and there were some provisions like that. I said, no, we have to follow the trust exactly as it's written. You shouldn't depart. What's the answer? I don't know. We settled both cases, so I don't know what the judge would decide. But these are really important issues, and you should think about that before you have equalization in your trust. So if you gave $200,000 to one kid and they bought a home, you gave a home to somebody, right? What's going to happen over the long period of time is that's going to start looking really unequal, right? Because the home's going to go up, maybe, and then this cash is going to be used for some other thing, maybe, right? Now, I'm not saying don't do the planning and don't do equalization. I'm just saying you got to have kind of a reality check when you're doing things like that. So then, what about single people? This is kind of an aside, but we have a lot of unique issues faced by singles. And I did mention the moving into a retirement home and using the charitable remainder trust. Partly that's because there's no children or spouse that you'd be disinheriting by giving to charity. But I also want to say we have planning issues too that are unique. And one of them is, well, we don't have a spouse or child that we can name as trustee or health agent. So you may have heard that there is a relatively new profession, although it's really not new in my world, it's been around for over 10 years, which is the professional fiduciary. So a lot of people have said, hey, I will name a bank. But you know what? Banks, you name a bank, they say no, because they say, no, sorry, this doesn't meet our criteria for what we're looking for. So you might name your favorite bank, and then they just decline to act. Well, then your family or your remote family has to go to a court to get a trustee named. Banks do say yes to some people, but they don't say yes when there's a lot of real estate and you're incapacitated, because how are they going to get paid, right? So then private professional fiduciary. So there's all kinds of different individuals who will go take a test, get a license, and then they're acting as a professional trustee. These are individuals from all kinds of walks of lives. Some of them have medical experience. Some of them are CPAs. Some of them worked as counselors or did social work. So I have one private professional fiduciary that I really use a lot for people with special needs. I have one that I use a lot with my elderly clients because they're just the most patient, most understanding. They love going to the house and going through all the papers and helping with the paper bills, and doing all of that. We have a lot of elder abuse issues with older single people because they don't have a big support network. So we want to get a team together. We want to have the financial advisor. We want to have the CPA. We want to have a professional fiduciary, a good professional fiduciary. And we want to have a lot of looks at the estate. I just dealt with a client. This is actually unrolling today. And she doesn't have any kids, no spouse. She has been friends with her financial advisor for like maybe 15 years. So they're both, financial advisor and friend. She wants to give her home to her financial advisor. So now there's nothing illegal with giving your home to your financial advisor. Like you can't look up and it says thou shalt not leave, thy home to a financial. But it's just very awkward that you have a financial planner, right? And then you're giving a home to them. And actually the law does say that's presumed to be undue influence. Now I really feel sorry for this client because she really feels closer to this financial planner than anyone else. So she wants to give her home to her. And so we're doing this whole process, right? We have medical review, we have multiple attorneys, we have an elder consultant, right? We're all writing reports because we don't want there to be any litigation. And she's going to do it at her desk. She's going to leave this home to her financial advisor. And I interviewed the financial advisor, right? We had this elder consultant do this report. There's interviews, all this stuff. Because have you ever seen what these lawsuits cost? What they look like? How many years? It's hundreds of thousands of dollars, 5 years. It can go into the millions of dollars, right? The litigation costs, if somebody wants to go in and challenge. Who would challenge? The siblings, right? That's her next of kin. The other charities that were listed under her estate plan before she left her home to her financial advisor because they say, under the prior trust, we were getting millions of dollars. Now we're not. And guess what? She had named like 20 charities. That's 20 potential people, entities that might sue you because they say, we should get more. Much younger spouses. I don't know what I can even say here. I had a client, it's his third wife. She's, 30 years younger than him, something like that. But there's a lot of issues. So one of them was, he's like, John, I want to create a trust for my spouse, put some life insurance in there, put some assets. The thing is, I don't know if I'm going to stay married to this spouse. Okay. Well, we could do what we call a floating spouse. So it's not her specifically, it's just whoever you happen to be married to at the time. I love it. Let's do it. Q-tips, I had a client who, he just passed away. He was in his 90s. His dad married a much younger spouse. He never got his inheritance. Never got it. He lived to his 90s too. But he never got his inheritance because his dad left everything in a Q-tip to his stepmother. And he was like, yeah, I understand it. It's fine. She's really healthy. She's in her 90s too, right? So he's the same age as his stepmom. But you got to think about this a little bit. If you have a much younger spouse, maybe you should leave something to your kids, right? In addition to your spouse, because they may never see their inheritance otherwise. Okay. So some case studies. I think I've gone over family business succession enough, so I'm going to skip that one. But I want to talk about, I had a client, a wonderful client, who had 4 kids, and she had 3 apartment complexes and a residence, okay? And it was like a $20 million estate. So she's like, I want to get each of these apartment complexes to the 3 kids, and I want to get the house to my daughter. and then I want to equalize. I want to make sure that it's equal. And I'm like, okay. All right, I think we can do this. We can do this. I'm like, okay, property tax reassessment, capital gains tax, estate and gift taxes, equalization. Got it. All right. Kids, do you want to hold on to these properties forever? Or if you sold them, would you do a tax-deferred exchange? Yes. Okay, great, good. Daughter, do you want to live in this home forever? Because if you sell this home and it's been gifted to you, you're going to have to pay all this capital gains tax, right? You want to be in here for, yes. Okay. So we did a QPERT for the home, but we were worried. We said, maybe mom is going to pass away soon. So, if you die during the term of a QPERT, the home comes back into your estate. Okay, let's hedge the risk. So we created 3 QPERTs. We put a third of the house in one QPERT, a third of the house in the other QPERT, a third of the house in the other QPERT, and that way, it's 2 years, 5 years, 8 years, and then the house phases in, right? She survived the 8 years, so we were able to get it out of the estate. Okay, property tax reassessment. Said, okay, we want to get these apartment complexes to kids. We don't want to pay higher property taxes. How can we do that? Okay, so we created 3 different LLCs, and we did minority transfers by gift sale. So remember I mentioned the IDGT trust? So we took back a note, right? And remember we got a discount in valuation because we valued the apartment complexes. We got an opinion, and we're like, okay, rents are down. There's a lot of uncertainty with the market. So we got a very low valuation. Took back a note, right? And then that gift sale was ignored for property tax reassessment purposes because when you change over a minority interest in an entity, there's no reassessment, right? Non-controlling entity. So we dissolved the LLCs and we did a fractional gift of the property, 2%. We created a new LLC, right? And then we did another round of gift sale transactions, but this time she has a minority interest in the new LLCs. So those are also ignored for property tax reassessment. But this time we did gifts. But now what we wanted to do was maximize her gift tax exclusion amount. So we had a lot of people added as beneficiaries of these trusts, right? We call those crummy beneficiaries. So we had some cousins, we had some nieces and nephews, right? And we had some other loved ones of hers, and we made them current beneficiaries of the trust with the ability for the trustee to make discretionary distributions to them, right? So that way we got her annual exclusion, which is $18,000, times each one of those people, and we had different people on each one of these trusts. So it was like, I don't know, maybe 10 people for each one. So each one of the trusts, we had like $180,000 that we could gift into all 4 of these trusts. So we did that each year, for each year of her life, and we were able to get everything out of her estate. So we paid no estate tax, had no property tax reassessment, and we got discounting, and she survived the term, and the kids got everything. So we, oops. Okay, I had another client who he has a commercial property partnership, and how are we on time? Okay, let's wrap it up with just questions. Did I wear everybody out? I could go all night. And it could just be reactions too. You might not have a question. It could be like, this is crazy. I just want to point out this is crazy.
Do you have a minimum that you work with?
A minimum?
Yeah. Can you repeat the question?
No, I don't have a minimum. I don't have a minimum.
He's been talking about really large wealth, right? Like the last client had over $20 million in real estate assets. So I'm asking, is there a minimum that you guys are looking for?
Well, I'll tell you, Jean asked me to do advanced estate planning. So I talked about my advanced clients. But I have clients that are normal too. I have clients that are like, $1.5 million house with like 2.3 kids, and they've got a dog, and they've been working really hard, and they contribute to their retirement plan. In fact, that's like a big group of my clients. They're just normal people like me, like I'm a normal person. I just happen to help really rich people. But then I also have a lot of clients that have like really significant wealth. So I do both. Yep. Good question.
Can I ask a question about the estate exemption amount?
Yeah.
That's going to change
Sure.
likely next year.
Right.
And just hypothetically, say we give out $5 million to a family, and under the calculation of 27 minus 5, I still have 22 million
Yeah.
exemption.
Right.
What if at the time we pass away, the 27 million is only 13 million? So what
Right.
is the total?
Can you repeat the question for the sake of the recording?
Okay, so the question was, what if, hypothetically, I gave $5 million away now that we have a $27 million exemption? Then what will be my exemption when the law expires? And it would have been $13 million. And the answer is your exemption would be, is it $8 million? Right? Is that 13 minus 5? 12, 11, 10, 9, 8 million. So, so that doesn't help you. Do you see how that doesn't help you? Do you see how it doesn't help you? Because for you to get the benefit of the current law, you'd have to give 13.61, like more than the difference between today's exemption and tomorrow's exemption. So you have 27 million, right? You have to give more than the difference between the two. Otherwise, you're not using anything more than what you'll have tomorrow, right? Unless the 5 million grows over time, then you're getting a benefit, but you're getting the benefit of just capturing growth out of your estate. Does that make sense? So the first question I ask when people say, hey, I want to take advantage of the current law, how big is your estate? Because if your estate's not bigger than the combined exemption amount after expiration, why are we talking about taking advantage of the current exemption today? Plus, did you know that you will probably pay more taxes if you have a non-taxable estate and you gift to your kids? This is a surprise for people because they say, well, I'm trying to save taxes, I should gift. No, because you will pay more in taxes. Capital gains taxes, right? You gift your home to your kid, you won't get a step up in basis at your death. You gift stock to your kids, you won't get a step up in basis to your... Now I say, well, it's a high basis asset. Yes, but how long are you going to live? So you could get that basis step up at your death. And did you know that married couples will get not one, but 2 step ups in basis?
What do you mean?
Well, if I die, there's a step up in basis for my assets, and then my wife gets another basis step up at her death. So that's pretty cool, right? Not my death, but the fact that my wife can sell the assets and not pay any capital gains tax.
How often, and if you could repeat this for the recording, but how often would you recommend people update their...
Great question. Wonderful question. So I think it's a good rule of thumb.
The question.
Oh, the question is how often should we update estate plans? And I think every 3 years is a good rule of thumb of coming into the attorney's office because that's enough time for your wealth to change and for the law to start evolving and your family situation to change, so you should have a conversation. I tell you, though, that I give my clients that are part of what we call our continuing care program an annual meeting. Some people take advantage of that annual meeting, some people don't. But if I'm meeting with somebody every year, we're not going to miss stuff. So you're not going to have this situation where there's this big, long list of things that have never been addressed. When I see those 20-year-old trusts, the list of things that haven't been addressed is so long, right? But I say, hey, there's no shame for anyone in my office. Everyone is welcome. And we just make sure that we keep it up to date going forward. Yep.
And about what are the fees look like for somebody who's just starting their trust as well as updating it if it hasn't been?
Okay. Well, we do a flat fee. Yeah, we do a flat fee of $46.50 when a married couple is doing a joint estate plan, or $34.50 when a single individual is doing an estate plan. And that's what we call core. So core planning is where they're setting up the basic documents like the trust, the power of attorney, the will, the healthcare directive. And that was last week's seminar when I went over the basics, like why do people have a health care directive? Why do people have a will? Why do people have a trust? So if you were like, where are all the basics? Like that's last week. So you could go look that up on your website, right?
Any other questions? Okay, well, thank you.
Thank you.